So thank you everybody for coming along tonight, and welcome to the first ever Speed Mooting Champion of Champions Moot. Tonight's event is an exhibition moot, and just to give you some background on the Speed Moot. So the National Speed Mooting Competition takes place once a year, and it's a competition for law undergraduate and GDL students across the nation to take part in. It's quite a unique competition in that students receive the brief and the moot problem the night before the competition. And the idea behind that is to replicate the situation in practice, whereby a solicitor or a barrister receives a late brief, they have very little time to prepare, and then have to go into court the next day and present the case. All of the case law and all of the legislation is provided. The skeleton arguments are pre-drafted, so students are only being tested on their oral advocacy. And we have up to 128 people that take part in a single day competition, and it works its way all the way down until we have a single participant left who is the winner. So we have the previous two winners who are competing against each other tonight. So in just a moment, I will hand over to our mooters to proceed. So the running order for tonight is that Robert will be representing the appellant, and Arya will be representing the respondent. And Robert, are you ready to proceed?
I am, yes, and thank you very much, first of all, John, for everything this evening and making it possible.
Oh, you're welcome.
Thank you.
Okay, all right. When you're ready, Robert, in your own time.
Thank you, my lords, and may it please the court. I, Mr. Allen, am representing the appellant Crown Prosecution Service in this case. My learned friend, Mr. Tabrizi, represents the respondent, Mr. Shafiq. The basis of this appeal is that the decision of the High Court, given on 25th October 2019, be overturned and Mr. Shafiq's conviction be reinstated. Would my lords care for a summary of the facts? I'll take that as yes. The Anytown Drifting Club, the ADC, is a members-only club. Members bring their cars to drift on a racetrack. To become a member, one must own a Japanese or German car, that car having at least 300 brake horsepower, and the individual must pay an annual £300 fee. Evidence of one's ability to comply must also be sent to the club manager prior to joining. The car park for the ADC is situated on Anytown High Street. There is one point of entry and exit, generally guarded by a barrier activated by a pressure pad. There are 35 spaces in that car park, and it can generally only be used by members. In its 10-year history, there have been no reports of non-members using that car park. On the night of 9th of March 2019, a Mr. Clinton Shafiq, a member, attended the ADC's 10th annual dinner in the clubhouse, parking his car in the car park. That night, members were entitled to bring with them a guest, each paying £30 a ticket. In total, there were 50 members alongside 50 guests in attendance. Those members were also entitled, as a one-off, to use the car park at a £1 fee. The barrier remained up all evening, and 30 cars were parked. At 10 p.m, a police constable spotted Mr. Shafiq getting into his car whilst attempting to move it to an alternative space in the car park. The constable suspected, correctly, that Mr. Shafiq was intoxicated over and above the legal limit. Mr. Shafiq was consequently arrested pursuant to Section 51A, the Road Traffic Act 1988. At first hearing, Mr. Shafiq pleaded not guilty. He did accept that he was over the prescribed limit, but claimed that the car park was a private place and therefore fell outside the scope of 51A. Having been convicted by a district judge at trial, Mr. Shafiq's conviction was later quashed by the High Court following his successful appeal. The Crown is now appealing this case to the Supreme Court on a point of law of general public importance, the sole issue in dispute being this: whether the ADC car park is to be regarded as a public or private place for the purposes of the Road Traffic Act. And those, my lords, are the facts. My lords, I wish to start by spending a short time establishing with some greater precision the question that I submit this court must answer prior to addressing my main submissions. For conviction, my lord, section 51A of the Road Traffic Act requires that Mr. Shafiq be driving in a public place. But what constitutes a public place? If I may turn your lordship's attention to the case of DPP and Vivier, 1991 RTR 205, which my lords will find at page 20 of the electronic bundle. And at this time, my lords, may I request to dispense with formal citations?
Yes, that's fine.
I'm grateful, thank you, my lord. Vivier adopted a justum generis approach to define public place as a place to which the public has access. Guidance on the term access hails from Pew and Knipe. At the middle of page 42 of your lordship's e-bundle, Lord Widgery states that the best way of showing access is to show that the public actually go there. This approach was further adopted in The Queen Against Spence. Lord Justice Henry at page 52 put it quite succinctly that this was a question not whether the public could have had access, but whether the public utilised that access. And my lords, I therefore submit that the question for the court is this: was the ADC car park a place that the public utilised? In my response, this appeal will show beyond reasonable doubt, as required by Pew and Knipe, that the question may be answered in the affirmative on the facts. My lords, I wish to present this appeal on two grounds. First, that even as a member of the ADC, Mr. Shafiq was a public person in a public place. Second, that Parliament could not have intended Section 51A not to apply in circumstances such as those before us. If I may then, my lords, turn to my first ground, that Mr. Shafiq's membership did not preclude the car park from being a public place. And if I may direct your lordship's attention to pages 26 to 28 of the e-bundle, DPP and Vivier once again, Mr. Justice Brown turns to examine Harrison and Hill at page 26, stating that private places are those occupied by a special class of members of the public. At page 28, Mr. Justice Brown sought to define special class persons as those who have gone through a screening process on account of some characteristic personal to themselves. This case distinguishes those individuals from the public at large, who may indeed be admitted, but only on the basis that they are willing to make some payment and meet whatever other conditions the landowner wishes to impose. I contend, my lords, that the facts of Vivier are not wholly dissimilar to the facts before us. That case concerned a caravan park, but those staying on the site had to register, they had to make payment and comply with various requirements. It was held that the mere premise that the caravan owners were prepared to satisfy conditions, that did not constitute their presence in a special class. The site was therefore held to be public. On our facts, my lords, there are 4 requirements for the aspiring member of the ADC. First, they own a Japanese or German car. Second, that the car has a minimum 300 brake horsepower. And third, that they send evidence of the above by email. Fourth, they must also make payment of £300 annually. We've already established from Vivier that payment on its own does not make one special. Indeed, anyone in the public, my lords, can be willing to pay. But what for the other requirements? Do they place Mr. Shafiq into a special class? This, my lords, is where our facts, I submit, are analogous with those in Vivier. Ownership of a caravan there was said simply to be showing a mere fondness for the activity in question. Likewise, I submit that whilst owning a German or Japanese car with 300 brake horsepower does indeed show some enthusiasm for driving pursuits, does show a fondness, arguably, for the activity, such cars are, in fact, relatively commonplace on our roads.
So to stop you, Mr. Allen, if I may.
Yes, madam.
If you could help me with this, you essentially say that Vivier is very similar to the facts of this case. The whole point about the caravan park, though, was that when people go to the caravan park, they are members of the public, and then when they satisfy the conditions by way of a booking and pay, they then become people who are going to the caravan park and part of a class. Whereas this case is slightly different, isn't it? Because in order for them to go to the club, they actually have had to join as members. So it's very different, isn't it, to the case of Vivier?
My lord, I'm grateful. If I could respond in this way, the reason that I submit the two cases are similar is on the grounds that Mr. Shafiq was a member of the public, and in joining at the ADC, he temporarily, and of course all memberships are temporary, he temporarily was admitted and able to enjoy the benefits of the club. And indeed the same for the caravan visitors, that they temporarily are afforded the enjoyment of the land. But I submit that those two temporary bases, one may indeed be considerably longer than the other, are both too modest to define those individuals as part of a special class. My lords, I would like to just summarise that, if I may, by saying that Mr. Shafiq was indeed an owner of one of these cars, but the cars were commonplace on the roads, that indeed there's nothing exclusive about them beyond the virtue of their price. And I therefore submit, as I answered to your lordship's question, that the ownership of that car is too modest a condition to render Mr. Shafiq as part of a special class, and that being so, the ADC was a public place. I would further submit, my lords, that the requirement to send proof of car ownership by email is not a scrupulous way of assessing the candidate for ADC membership. Vivier raised Panama and Newbury at page 28 of the e-bundle. In Panama, club membership was held not to constitute preclusion of public entertainment on the grounds that there was no form of rigorous selection process. On our facts, my lords, anyone could send an email to the club manager claiming to satisfy the criteria. Where other clubs may indeed require members are nominated, proposed, seconded, interviews conducted, the check and balance here by ADC is nothing more than a formality, I submit. And I submit to your lords that if a special class could be formed by such lackadaisical means as these, a great many of us would find ourselves it rather easy to be considered a special class. My lords, with your permission, I now wish to move to the second.
Alan, before you do, yes. Just one more point on that. So if you had, for example, the local Labour club or the local Conservative club, by your definition, they would never become private places. They'd always be public then, is that right?
My lords, it is, and this is not refusing to answer that question, but it is for your lordships to devise that test. My own interpretation of the law as it stands is that it is valuable to have some form of qualifying factor, be that in some form of expertise or skill, but that mere ownership of something is not enough. So both on the rigour aspect of joining and on the aspect of possessing the criteria to become part of a special class, there must be some measurable means beyond ownership and sending of an email in order to be able to define someone in those terms that were put by his lordship. If I may, with permission, my lords, move on to the second ground of appeal. There has been much discussion in previous case law throughout the e-bundle on the purpose of section 5.1a, the Road Traffic Act itself. If your lordships wish to turn, by way of example, to page 43 of the e-bundle, my lords, Lord Justice Watkins utilised there the mischief rule in application to the multi-storey car park case of Bowman and DPP. His lordship posed that section 5.1a exists in its essence to protect people from injury and property from damage. But that said, his lordship felt reluctantly unable in the circumstances to interpret the statute broadly to define that car park as public. Why? At first, I submit, because the case was heard in the High Court. Your lordships need no reminding that this is the first time this matter has been brought before the Supreme Court. And this, of course, grants the opportunity to draw a clear line under the stream of conflicting Court of Appeal and High Court decisions and clarify the law with policy in mind. Your lordships are not bound, as at paragraph 35 of page 60, Mr. Justice Mitting expressed in DPP and Cowan, to apply highly undesirable law. Second, I submit Bowman was not interpreted broadly because the multi-storey car park was near empty. It was held that the potential risk was low. Contrast that, my lords, with our present case. A small car park with 30 cars contained. Inside the clubhouse, 100 partygoers, drinking, celebrating dinner. I submit, my lords, that in their jovial spirit, it is not unreasonable by any means to imagine those persons spilling out, having finished their dinner and coming under grave threat from Mr. Shafiq's drunk driving.
Mr. Allen, if I may.
Yes. Thank you, my lord.
That is a hypothetical, isn't it? You have no evidence before the court that the public were indeed using that car park, do you?
That is, I'm grateful, my lord, and that is the case in these circumstances. But my second submission to your lordships is that it is highly fortunate that in this case nobody was hurt, that no property damage was done, and that on policy grounds, given the extensive discussion in previous case law, when the Court of Appeal has been unable to find a route forwards, that this evening presents an opportunity for your lordships to apply policy and consider what the circumstances could have been in other events. My lords, given the circumstances in contention this evening, that the ADC membership requirements were modest to say the very best, and that Parliament surely cannot have intended Section 5.1a to allow individuals to drive drunk in a busy car park in close proximity to high numbers of people. I plea, my lords, that you will find satisfied the answer to the question that I first posed, that the ADC car park was a place that the public utilised, and thus, my lords, will grant this appeal. This marks the end of my submissions, unless I can assist your lordships any further. Thank you.
Mr. Allen, could I just raise this, please? Would it not be undesirable from the point of view of public protection to turn every private car park into a public place? And as has already been put to you, and particularly with reference to the case of Pew and Knipe, is it not the case that there is no evidence here that any member of the public not only used this car park on the evening, but indeed had used it for the past 10 years? And in addition, that surely this was a private car park because the only people entitled to be present that night were there by specific invitation. So what would you say to that point, Mr. Allen?
My lord, I'm extremely grateful. If I may answer it like this, the second submission on policy grounds, I wish to be very much tempered by my first submission on the grounds that the membership criteria in this particular case was not satisfactory to define the club as being a private place. Now, there may be other circumstances, as your lordship raises, where it is a wholly private environment, the car park is private, and therefore the law of Section 5.1a would not apply. But that first submission is to argue that in these particular circumstances, that criteria has not been met. The conditions are too modest. with respect to your Lordship's second point, this is why my submissions have not focused with any great regard to the visitor aspect, because indeed the visitors, it is, and I'm sure my learned friend may address this, can be argued to be there as an attachment of those members. So it's my primary submission, your Lordship, that the members themselves were not private by warrant of the fact that the conditions that they were required to meet were far too modest to deem them in those terms.
So, Mr. Allen, do you concede then that if we are not with you on your first submission, that you have no evidence that the car park has been used by the public?
My Lord, it would be a far weaker submission to argue on the basis of visitors. I have spent my time this evening on the primary argument, the first submission, being that the membership criteria are too modest. I submit that that is a strong basis to define this car park as being public because of the case law that currently exists, because of the facts that are so similar. So it is less of a focus, you're right your Lordship is right in saying that the visitors were there, but more so that the members themselves, and I submit confidently that the members themselves were indeed not meeting conditions that were rigorous enough to define as private.
I have nothing further. I don't know if my fellow judges do.
No, thank you, Mr. Allen.
Thank you, I'm extremely grateful.
Mr. Tabrizi.
I'm grateful. If it pleases the court, my name is Arya Tabrizi. I act, as has been mentioned, as counsel for the respondent in this matter. My lords, I'm grateful for my learned opponent's summary of the facts, and we adopt those unless otherwise stated. The court is, of course, well aware at this point what the salient issue is before it, and I don't intend to labour on that, but clearly the salient issue in this matter is whether the car park of the ADC was a public place for the purpose of Section 5 offence. We say, of course, that it wasn't, and we have 3 submissions to make in support of that. Can I just check with the court that your lordships have had sight of our skeleton argument at pages 16 and 17?
Yes.
I'm grateful, my lord. I first plan to deal with the burden on the Crown and whether they've discharged that burden in evidencing that the car park was used by the public in general. I then plan to deal with the 2 classes of people that were present at the car park on the night in question. We say there were 2, and I believe that's uncontroversial, members and guests. If I can assist the court no further on any preliminary matter, I plan to move on to my first submission, which is general public use. Our first submission is that because the car park of the ADC is prima facie a private land, the Crown must establish, it is necessary for the Crown to establish that the land is used by the general public if it is to satisfy the meaning of a public place for our purposes. We say that they have failed to do this, and we go further, and we say that not only have they failed to do this, but actually the facts before the court are a stark example of a place which is ostensibly not a public place. And the case we rely on, which is our most important precedent, we say that this case is on all fours, on all material fours, with that of Pugh and Knight. If I can take the court to, the case begins at page 45, but I plan to take your lordships to specific parts of the judgment starting at page 49. And it's the divisional court led by, as he was then, Lord Chief Justice Widgery, so not binding, but of course of some persuasion to even this court. And At page 49, it's the first paragraph, second sentence. The manager, however, did not speak, and this is very important, to any actual specified use of the car park by persons other than members or their guests. Well, in Pugh and Knight, the court held that on facts very similar to this, a car park of a members club was not a public place, and they relied in doing so on the fact that there was no evidence before the court at first instance that members of the general public used that car park. And we say that the court is obliged to find the same here. And if I can take, just for completeness, the court down to page 50, again, it's the judgment, the single unanimous judgment of Lord Chief Justice Widgery. And it's the first paragraph halfway down. And I don't intend to read the entire passage to the court, but it starts off accordingly, in order to turn what on the face of it is a piece of private land, namely the private car park, into a public place, it is necessary, in my judgment, to show that the public have access to it. And his lordship goes on to say that perhaps the only way of establishing that is to show that the public did in fact use it.
Mr. Tabrizi, perhaps the preliminary issue should be for you to deal with Mr. Allen's submission that actually it never was private in the first place. You're going on the basis that it's accepted that it's private land, but we've heard from Mr. Allen that the Crown don't accept that mere membership of this club means that the space is private. In fact, he starts from the premise that actually it's public and always is public. What do you say to that?
I'm grateful, my lord, and I will indeed deal with my learned opponent's submissions in regards to the class of person being the membership being a public class of person. We say that it isn't. When I speak of the land being prima facie private, what we say by that is that clearly this is not a public highway. It is a privately owned piece of land. And in order to show that a privately owned piece of land is a public place for the purposes of this act, one has to show that the public have access to it. And we say the Crown have not evidenced that. In fact, on the facts before the court, the material facts before the court today are what? That members and guests only were invited on the night in question, and that there had been no use of the car park by the public for 10 years. That's insufficient to satisfy the burden incumbent upon them to show that it is a public place, and the burden is theirs to prove, and they have not done so. If I can address your lordship's question more specifically in regards to membership, if I can draw the court's attention to the Crown and Spence, it's page 54 in particular of the bundle. The Crown and Spence was a Court of Appeal case. It concerned dangerous driving in a car park attached to an office building. And the Court of Appeal considered what constituted a special class of person so as to be distinct from general members of the public. And at page 54, paragraph 7, Lord Justice Henry stated, the evidence in this case is that it was employees, customers, and business visitors who used the car park, led us to the conclusion that those categories of people were of a special class, those with business there. Now, turning to our facts, my lords, what class of person, what requirements does an individual have to satisfy to become the class of person known as a member? Well, you've heard from my learned opponent that it's mere ownership of a car. That's simply not the case. It's £300 in annual fees, which is not an insignificant amount, but we would perhaps concede not sufficient in and of itself to distinguish members from the general public at large. But it's then ownership of not just the car, and we would say that at this point is becoming sufficient, but it's ownership of a German or Japanese car with a certain specification. It's proving that you meet those requirements in advance of signing up for a membership, a continual membership, an indefinite annual membership. It is not, like in the case of Vivier, cited before the court previously, merely turning up and paying an entrance fee at any point in time that you may choose. And that, we say, is important. That takes members of the ADC from individuals of members of the public at large utilizing a place or a service at a cost to members of a private class. Can I assist the court any further on that?
I apologise for interrupting you, but you've just detailed the preliminary requirements to become a member of this drifting club. But looking at the matter pragmatically, in terms of what a member of the public might find on the night, wasn't it the case that the barrier to this car park was raised, and this is a car park situated just off the high street of any town? So is there not therefore an implied right for the public to access that car park?
I'm grateful, my lord. We take your point. We certainly can see that that's perhaps the strongest line of argument against the respondent. But what we say to that is that the barrier which usually demarcates the car park from the public highway being up is not sufficient to transform that place from one which the public do not have access to into one into which the public do have access to. And in support of that, because it is a very valid point your lordship raises, if I can take you to page 48 of the bundle, and again it's Pugh and Knight, and it's worth reminding the court at this point that in Pugh and Knight there were no barriers, there was no signage, and there was no demarcation between the car park of the country club and the roadway which allowed access to it. But if I can take you to page 48, and it's the fourth paragraph down, or 3/4 into that paragraph, and it's the segment that begins, "I interpret that to mean," and his lordship has just explained that the club allow vehicles up to the front entrance of the club through the car park. They allow it, they permit it, one might say they encourage it, in order to drop and pick members up. And he says, his lordship says of this, "I interpret that to mean, and have consistently interpreted it to mean, that if a vehicle seeks to approach the front entrance of the club in order to pick up or set down passengers, such a vehicle is allowed to do so. Indeed, it is a fairly obvious conclusion. I do not read that finding as meaning that the public at large, in any sense, are given access to the area in front of the door of the club." We would say a mere raising of the barrier that usually prevents access falls in line with the reasoning of his lordship there in Pugh and Knight. It's not sufficient to transform what is a private area into a public one, especially when the Crown haven't evidenced any use of such by the public on the night in question. My lord, can I assist you any further on that point?
No, thank you, Mr. Tabrizi.
Mr. Tabrizi, I quickly have a point in relation to that. If I can take you to page 50 of Lord Widgery's comments, because he was very much troubled with this case, wasn't he? He actually believed that it could have been found that this was a public place if the magistrate had drawn specific inferences from the evidence. So the case doesn't give you authority, does it, to simply say, well, because you can't just simply, if there's a barrier there, that's not enough to make it a public place if it's raised, because he said this, "I feel, looking at this as an observer, that the probability may well be that they did use it. In other words, the public did probably use that car park. And if we look at the map in this case, and what my fellow Lord Rogerson said, that it's very close to the road, you could draw an inference, couldn't you, that the public probably do use this car park. And in those circumstances, there would be evidence to infer that it is used by the public. And if the court below, if the magistrates had originally come to that conclusion, then as Lord Widgery had says, if the magistrate had come to that conclusion, that would have been the end of it. So this authority doesn't give us authority to basically say that, well, if the public could access it, that's not enough. It actually says that you could actually infer from that they do in fact access it. Do you see my point?
I take your lordship's point, and your lordship is quite correct. One could draw at a fact-finding trial, one could, upon presentation of all the available evidence, draw such an inference if it was so appropriate. We say that's not the case here. It is worth reminding, though, of course, there is no need, the court, that the burden is on the Crown in this particular matter. They have not been able to establish or persuade the lower courts to draw such an inference. We would say it would be inappropriate for this court to draw an inference of that at this stage. And all we say is we don't rely on that passage of Pew and Knight to say that there is always, or that it is always going to be insufficient. It's not always insufficient to show that merely because the public have access to it, that's insufficient to show that it isn't a public place. At times it might well be, but it is fact dependent. And again, in this particular case, that has not been evidenced. And I won't draw into issues of whether it should have been, but of course it hasn't been. And therefore we say that with respect, this court's hands are tied in that sense. My lord, if I can assist you no further on that point, I am wary of time. I had anticipated dealing with the visitors on the line as a separate class of person. If the court could perhaps indicate to me whether they'd still like me to address them briefly on that. I'm aware that my learned opponent didn't feel fit to make any positive argument as such.
Mr. Tabrizi, I was going to ask you specifically, and your learned friend may have made a somewhat jovial and flippant comment about the readily availability of high-powered German or Japanese motor cars in today's society, and it may well be that we agree or disagree with him on that particular point. However, the difficulty as I see it is this, that whilst you may scrape over the line in respect of the ordinary members of the club having a particular condition that they have to settle, the guests of those members did not, did they? They merely had to drive in, pay a fee, and they could enter the premises.
I'm grateful, my lord. I will address your question briefly, if time allows. In doing so, we say this: there is one very clearly discernible quality to guests of members that night. And we say that it is they were invited by members of the club. These individuals share a quality that they were invited by members of the club upon the club's permission to attend the premises that evening, and they entered the premises in order to attend that specific one-off event to which they were invited. And we say that this does not, that it means they are incapable of being considered members of the public at large. Because when one looks at the case law, and I don't know if I have time to take the court there now, but the case that was cited in our skeleton argument is Cowan and DPP, and it's page 58 of the bundle for completeness. But when one looks at the case law, there is an either-or test. Either the class of person has to have a special characteristic or condition, or they have to be in attendance for a specific purpose personal to themselves or the occupier. And we say that the visitors or the guests on that night satisfy that second alternative of the test. They were there for a very specific purpose, personal to themselves, personal to the members, and for that reason, to call them members of the public at large would be incorrect, would be plainly incorrect in our submissions. for that reason and that reason alone, my lord. Can I assist you any further on that point?
No, thank you, Mr. Tabrizi.
I'm grateful. In conclusion, my lords, to allow this appeal would serve injustice in the present matter. Perhaps more importantly, it would undermine a lengthy history of case law and conduct, which Parliament has had ample opportunity to alter if it so wished. We say that the case law is clear, that situations, factual matrices such as this, do not lend themselves to being a public place. Parliament has had plenty of opportunity in the various reenactments of the Road Traffic Act to amend that or to make it clearer. They have failed to do so. For that reason, we say it would be inappropriate for this court, as implored by my learned friend, to act in its limited policy capacity and alter the state of the common law and the definition of what constitutes a public place for the purposes of a Section 5 offence. For those reasons and those previously expounded, we invite the court to dismiss the appeal. And if I can be of no further assistance, that concludes my submissions.
Thank you, Mr. Tabrizi. My lords, is there anything that you would seek to ask? I'm grateful. Gentlemen will rise.
It's fallen to me to give the judgment of the court. Since 1931, this is an issue that has come before the courts time and time again. At last, it can be resolved by the highest court in the land. Most of the authorities before us cite as their starting point the case of Harrison and Hill of 1932, originating from the Scottish High Court of Judiciary. The fact it's a Scottish case, we don't hold it against them. It was in this case where Lord Clyde, the Lord Justice General, made it plain that there is a distinction between the public generally as opposed to special classes of members of the public. This has been a theme which has repeated throughout the judgments that followed. He said further in the case that there must be, as a matter of fact, walking or driving by the public on the road or public place, and such walking or driving must be lawfully performed. In the Court of Appeal case cited in one of the authorities, the case of Crown against Waters, there's a Court of Appeal that said if only a restricted class of person is permitted or invited to have access, the case would fall on the side of the place being private. If only a restricted class is excluded, the place would be public. The case of Pugh and Knipe has been cited, and it was said that in order to turn what was prima facie private land into public place, it was necessary to establish that the public had access to the place. And as Lord Justice Widgery said in that case, the best way of showing that the public have access to that place is to show that they actually go there. Now, on the agreed facts, it is clear that hitherto there has been no public encroachment on what obviously is private land. It was first thought that the prosecution's case would be that the guests going on this occasion made the land public. Well, Mr. Allen has gone off his skeleton argument that was provided to the court and instead argued that in the first place that the members of the club were still public. Well, that is a submission that this court does not agree with. He then conceded that if he lost that argument, that he was only left with a policy argument, which I'll come to in a moment. The crux really in this case is whether the guests are members of the public or whether they have unique characteristics that they are not members of the public. Have they inherited the characteristics of the people they are with? And it's clear from the cases that have been cited, particularly the case of Cohen is of assistance here, that they are, the 50 guests were certainly not members of the ordinary public. And Mr. Allen's policy argument was threadbare at best, nonsensical at worst, and quite frankly, we didn't agree with him. And so for those reasons, the appeal by the Crown is dismissed and the defendant, the respondent, is allowed to continue getting drunk and drive his merry way. That's the judgment of the court, and I think we're now going to give some feedback.
Yes, if you could, that would be fantastic.
Who's first?
Okay, gentlemen. Just because, Mr. Allen, you lost on the law, overall we came to the conclusion that in terms of your mooting, you were the winner. Our feedback, and we've had quite a discussion about this, and I'll do a little bit, and I'm sure Gerard will do some, and then Darren will do some, or whichever way round we go. One thing I say to you, Robert, is the second time I've seen you moot now, because I actually judged you in the final on the last occasion, but be a little bit more careful about drawing analogies. When I say drawing analogies, is you may one day find yourself in front of a left-leaning judge who, if you tell him that generally there are vast amounts of high-powered German motor cars around that all people are now driving, you may find that he's or she is less inclined to favour you on that particular point and ask you to go and throw yourself in the pits of Oldham for a couple of weeks and see what the real world is like. So be a little bit more.
If I may, if it's any consolation, I actually drive a rather run-down Vauxhall, so so it's not me. But yeah, thank you. Just be careful, a little bit more careful about your analogies, because you don't know your tribunal that well as to know whether or not they will be good-humoured about it or not be good-humoured about it, as it were. Something that both of you did, and it's a consequence of mooting. That you focus a great deal on etiquette and the way etiquette works and the way you think you should be talking to the court and how you go about talking to the court. I'm afraid hacks certainly like me and Gerard are certainly of the school of thought that you get in, you get on with it, and you get done. Yes, I appreciate that there is a marking scheme and where you're expected to say certain things and use certain phrases, but there comes a point where they become a bit repetitive. And actually they're detracting away from what you're actually trying to tell us, which is why we should accept your position on the law as opposed to why we should why we should reject that. And if I'm getting lost in may I please say this and may I move on to that, and however many times you can say, you know, how much more can I assist you? And there are more platitudes in there than there is legal argument, then you're not really making legal argument. And remember, you're time limited in there. So you'll be forgiven for just getting on with it. In actual fact, you may find that your tribunal is a little bit more receptive to that as a form of advocacy than they are of a very, I'd say, antiquated language in terms of how you address the court. Certainly that was more something that, Arya, that we found in respect of your advocacy was something a little bit more prevalent. Robert, overall, you were both, in fairness, you were both very polished and you were both very impressive in terms of mooters. And your advocacy style was warm and quite welcoming. It's just that, Robert, you picked Arya a little bit in terms of, and it may be our fault because you got a little bit of a settling in period by telling us what the facts of the case were. So you then picked up more of a stride. But unfortunately, as the respondent, you're straight into it, looking at our ugly faces, going, "Oh my God, what am I supposed to do with this now?" Something that was drawn out in the judgment, of course, Robert, is you didn't deal with one particular point, which would have probably nipped you over the line in terms of the legal argument, which was, well, yes, I may not get very far on the issue of the club members and their membership, but actually the guest, I'm sure as hell going to get you on that. And for that one night only, we probably would have found and made an inference that they were members of the public that were using it as public, and it was a public place, because there's nothing to say that we can't give a degree of fluidity about it and say that a private piece of land can become public, dependent on the people that are using the piece of land at the time they're using it. So, yes, and that then takes you back to what you were talking about in Pure Night, actually, and that was drawn out in terms of one of the questions that was asked was, actually, if we'd have been invited to make certain inferences, you may well have found us on a different
on a different footing altogether in terms of our decision on the law, but there we go. There was nothing in terms of nervous twitches or tics that we could identify. A couple of drops in here and there, but you know, there's nothing wrong with that, and you'll be forgiven for doing that. All I'd say is, as well, in terms of make sure signposting was quite clear that you both were well equipped in terms of the brief and the brief that you were dealing with. Whether it's because John's used this moot problem about 4,000 times now, I'm not quite sure, but and you were both very good with the authorities. In fact, Arya, I'd say that you drew us more towards specific parts of authorities than perhaps Robert you did, but which was a more broad brush approach in terms of your submission. But yeah, if there's a skeleton argument, Robert, and if you are going to go off the skeleton argument, tell us you're going off the skeleton argument. Otherwise, we're looking at your written arguments going, well, this has nothing to do with what he's put before us here. There we go. So that's my, for what it's worth, what I thought and what we potentially collectively thought. But I'll let somebody else do the talking now because I've talked too much.
I can be just a little bit picky for both of you, if I may. Arya, in particular, there were a couple of things that you said. We didn't like you saying we say and they say. You know, the respondent's contention would have been a better way of dealing with that. It's a small point, but reducing it into we and they just didn't really have that sort of court etiquette about it, if you like. We thought as well that you were rather in danger, Arya, with one comment when you said, we say the court is obliged to find the case is the same here. Well, of course we're not. So just be very careful about sort of sweeping statements like that. But both of you, in terms of your organisation of it overall, good. There was a lack, as Callum has said, there was a lack of irritating tics or too many ers or nervous habits or anything like that. So you were both quite compelling storytellers when it came to that. Yeah, I think coming to Robert, what we did like as well was, although in a way you maybe didn't make the most of it, what was quite a novel thing you did when you first started speaking to us was to say that you were going to set out a question. And that was quite a nice way to approach it. We liked that, albeit we weren't entirely convinced that you set out the right question or set it out in the right way. But nevertheless, it's a useful way, and it goes back to what Callum said about signposting. So that was a good technique. And I think that's pretty much my nitpicking done with. Two very good performances, but just felt on balance that perhaps the more confident storytelling, if you like, lay with Robert.
I have nothing else to add because I know the time is running on, so well done both of you.
I just want to say thank you to the judges and obviously congratulations to Robert.
Thank you very much. I'd like to thank both of you for competing tonight and all of our judges for the feedback. Well done. Congratulations, Robert. First ever champion of champions. Champion. And well done to you as well, Arya. You did well tonight. I certainly didn't envy the judges. It would have been a really tough moot to call there. I certainly couldn't have called it. And as Callum says, that problem has been used before. Who would have thought we'd have a number of barristers talking on YouTube about drifting in Japanese cars? But there we are. So thank you very much to everybody that's come tonight. Really appreciate the effort. We will have a number of subsequent events coming up. So during the month of October, there are going to be 4 more Q&A sessions. Each is going to be focused on a specific area of law. So sign up for that will be launched next week. So if you keep an eye on our social media, it's always at Speed Mooting or the website. You'll be able to find details for those events. I have had a number of inquiries recently about mooting. I'm looking to have some sort of virtual competitions arranged shortly. So hopefully if you've watched tonight and you thought I quite fancy a go of that, I'll be opening up the opportunity for more people to have a go at mooting soon. So that brings us to the end of the evening. Once again, thank you to everybody for taking part. Tonight's event has been sponsored by publicspeakingtuition.com.